Now, let's go to another topic. I am talking about the case of People versus Marlon Cristobal, GR number 234207, dated June 10, 2019. The question is, does this case of People versus Marlon Cristobal prove that reckless driving is not a crime? Let us first go through the facts of the case. Cristobal was charged for illegal possession of dangerous drugs in the regional trial court. According to the police, Cristobal was flagged down at a checkpoint for not wearing a helmet. He also failed to show the certificate of registration and the OR of the motorcycle he was riding or driving. While the police officer was preparing the traffic citation ticket, Cristobal allegedly ran away, but the other police officers were able to apprehend him. He was brought back to the checkpoint where he was searched for deadly weapons, but nothing was found. However, the police noticed that Cristobal's pocket was bulging and ordered him to remove the object from his pocket, which was a small plastic bag. When the police opened the same, they found 7 plastic sachets containing white crystalline substance, which turned out to be methamphetamine hydrochloride, or more popularly known as shabu. The RTC convicted him of the charge. According to the RTC, the search made on Cristobal was justified under the stop and frisk rule. On appeal in the Court of Appeals, the Court of Appeals affirmed the conviction of Cristobal. On appeal in the Supreme Court, however, acquitted Cristobal. The reasons cited by the Supreme Court in acquitting Cristobal are as follows. First, there was no valid search incidental to a lawful arrest. There was no arrest to speak of because the violations committed by Cristobal are both punishable only by a fine. Take note that the fine under RA 10054, otherwise known as the Motorcycle Helmet Act of 2009, is in the nature of a criminal penalty, while the fine under LTO Department Order number 2008-39 is in the nature of an administrative penalty. There being no lawful arrest, the sachets of shabu were discovered through an unlawful search and thereby inadmissible in evidence against Cristobal. Now, the Supreme Court further said that the case of Cristobal is strikingly similar to the case of Luz versus People. In the said case, the Supreme Court likewise acquitted the petitioner because the failure to wear a helmet under a city ordinance or penalized under a city ordinance is punishable only by a fine. Now, under the rules of court, a warrant of arrest need not be issued if the information or charge was filed for an offense penalized by a fine only. It may be stated as a corollary that neither can a warrantless arrest be made for such an offense. Now, the SC also stated that neither could the search on Cristobal be justified as a valid stop and frisk search. However, we will no longer discuss it here because it has no bearing to the question of whether or not reckless driving is a crime. Now, does the Cristobal case prove that reckless driving is not a crime? The answer is no. Why? First, the case is about the illegal search made on Cristobal that led to his acquittal of the drug charges. It does not talk about reckless driving and whether or not reckless driving is a crime. Second, there was no lawful arrest to speak of, not because Section 7 of RA 10054 is not a crime, but because the violation imposes only a criminal penalty of fine. To reiterate what the Supreme Court said in Cristobal, A warrant of arrest need not be issued in the case of a person who violates a penal law that imposes only a penalty of fine. Neither can a warrantless arrest be made for such an offense. Third, it is wrong to say that it is not a crime when the law imposes only a penalty of fine. In criminal law, it is basic knowledge that punishment for a crime can be either a fine or imprisonment or both such imprisonment and fine. And fourth, nothing in the Cristobal case says that a traffic violation is not a crime. To reiterate, violations of traffic laws, rules, and regulations are categorized as criminal cases governed by the rules on expedited procedures in the first level courts. This was approved by the Supreme Court en banc on March 1, 2022, and which took effect only recently on April 11, 2022. The assertion, therefore, that the Cristobal case proves that reckless driving is not a crime or that a traffic violation is not a crime is highly erroneous.